Judge Jones tries to stop Jasmine Crockett. What she says next silences the entire courtroom. The hushed grandeur of Houston's federal courthouse had never sounded louder. Marble columns seemed to vibrate beneath the silence as Congresswoman Jasmine Crockett, only 5'3" but radiating 6'5" confidence, took her place at the podium. Cameras clicked, pens froze, and even the ceiling fans felt as if they'd stopped mid-whirl. This was supposed to be a routine hearing on Texas's latest voting rights lawsuit, yet every reporter in the gallery sensed something seismic brewing, an invisible pressure that tasted like metal on the tongue. Seated above her, Judge Edith Holland Jones, legend of the Fifth Circuit, 4 decades deep, spine straight as a rifle barrel, leaned forward, robes rippling like an onyx wave. To legal insiders, she was the Iron Eagle, renowned for slicing attorneys apart with a single raised eyebrow. To civil rights advocates, she was the final boss of voter suppression, a gatekeeper who could bar millions from the polls with the stroke of a pen. Crockett knew all that, yet her gaze never wavered. Somewhere in the briefcase at her feet lay a manila folder thick with ammunition, Jones's own quotes, rulings, and, if rumors were true, a recording explosive enough to crater a career. Crockett inhaled, ready to cite constitutional clauses, demographic data, and lived realities of voters sidelined by photo ID hurdles. But she got out exactly 5 words. "Your Honors, the evidence shows," before Judge Jones's voice, hard as gravel on steel, cut her off. "Congresswoman, I've had enough of these baseless claims." The words ricocheted through wood-paneled walls like a starter pistol, and the courtroom collective held its breath. A sitting federal judge had just branded a black congresswoman's testimony grandstanding before it even began. In a nation already roiling over judicial bias, that single interruption felt like a match hovering over dry prairie grass. What Jones didn't know, Crockett's legal mind was a pressure cooker. 15 years battling Texas voter suppression tactics had trained her to turn slights into stratagems. Behind her calm eyes, years of poll closure maps, affidavit stacks, and overturned judgments assembled themselves into a tactical formation. If Jones wanted fireworks, Crockett would supply the grand finale. And outside, the storm was already coiling. Protesters with placards reading "No judge above the law" ringed the courthouse steps. Cable news vans idled, technicians poised to flip breaking banners the instant screens lit up. On social media, the hashtag voting rights showdown simmered, one tap away from boil. Every player sensed that today could redraw the fine print of democracy or expose the handwriting that had been there all along. Crockett straightened a single sheet of notes, but what she really gripped was resolve. She'd watched elders in her Dallas district wait 10 hours in line to cast ballots. She'd listened to grandparents recount literacy tests and poll taxes like yesterday's weather, and she was done watching communities be muted by gavel-wielding power. "Your Honor," she replied, voice steady yet carrying the weight of generations. "With respect, the Constitution calls these facts. Ignoring them doesn't make them disappear." A ripple, half gasp, half cheer, rolled through the gallery. Jones's eyes narrowed into flint. That was the moment 2 American eras locked horns, one robbed in decades of untouchable authority, the other wrapped in data, documents, and unapologetic audacity. What happened next would rocket through Twitter feeds, topple a judicial titan, and crown a new icon of accountability. But first, the courthouse had to survive the impact of one congresswoman's folder and the truth waiting to detonate inside. The heavy doors of Houston's federal courthouse swung shut behind the crowds, sealing in an electric sense of anticipation. Every seat was filled by veteran lawyers, civil rights advocates, and national reporters, each person acutely aware that this was more than a routine hearing. At its heart, this day revolved around 2 singular figures, a formidable black congresswoman and a legendary conservative judge colliding on the nation's front line of voting rights. At center stage, Congresswoman Jasmine Crockett. A civil rights lawyer turned progressive lawmaker, Crockett's rise was anything but predictable. Raised in St. Louis, transformed by first-hand experiences with racial injustice, and honed in Dallas's toughest courtrooms, she'd built her reputation one underdog case at a time. Tireless, fiercely articulate, and unflinching in the face of power, she had made a name for representing the marginalized, stepping in for BLM protesters and indigent clients when other attorneys would not. As soon as she entered the courtroom, her presence signaled that today would be about more than legal arguments. It would be about challenging entrenched systems. Behind the bench, Judge Edith Jones cut a starkly different figure. Born in Philadelphia but shaped by Texas's legal corridors, Jones was a Reagan appointee with 4 decades on the bench, her glare enough to silence seasoned lawyers. A record of hardline decisions on abortion, civil rights, and criminal cases preceded her. She rose to become Chief Judge of the Fifth Circuit from 2006 to 2012 and has been repeatedly discussed as a conservative contender for the Supreme Court. Her reputation was unbreakable, decisive, exacting, and, in her critics' view, emblematic of the old guard who believed in keeping the judiciary insulated from challenge or change. Within minutes of opening arguments, the atmosphere shifted. Crockett began to calmly outline evidence of voting rights violations, data points, court precedents, lived realities. Judge Jones leaned forward, her face hardening with every word. Suddenly, the judge cut in. "Congresswoman, I've heard enough of these baseless claims. This court doesn't have time for political grandstanding." The words echoed through the chamber like a pistol crack. The audience froze. A sitting federal judge had silenced a black congresswoman testifying on civil rights, an interruption charged not only with personal tension but symbolic weight. Yet Crockett's response was steel-edged and direct. Years of courtroom experience flickered in her controlled reply. "With respect, Your Honor, these aren't baseless. They're constitutional violations backed by evidence, and this court owes them a hearing." For a heartbeat, decades of tradition, where judges' authority was rarely questioned, hung in limbo. Observers realized this was no ordinary legal sparring. Power, race, and reform clashed in real time, the old era of judicial deference colliding with a new demand for transparency. This wasn't just about one law or one courtroom. It was about whether American justice could still transform, even when tradition insisted it stand still. The collision of these two titans would mark the start of a confrontation destined to reverberate far beyond Houston, setting the stage for a dramatic reckoning neither side would ever forget. Seated atop Houston's federal bench, Judge Edith Holland Jones commands attention the way a thunderhead commands a summer sky, imposing, inescapable, and charged with unpredictable force. At first glance, she resembles the blueprint of establishment power. Philadelphia-born, San Antonio raised, top of her high school class, national merit scholar, then honors degrees from Cornell and the University of Texas School of Law. By age 36, Jones had already shattered glass ceilings in Houston's old guard legal world, becoming the first woman partner at Andrews Kurth Campbell Jones, a move that signaled her appetite for both legal intricacy and institutional gatekeeping. Her resume gleams with accolades. She took her seat on the U.S. Court of Appeals for the Fifth Circuit in 1985, appointed by Ronald Reagan, and soon developed a reputation for uncompromising constitutional conservatism. She rose to Chief Judge in 2006, a post she held for 6 years, and sat in judgment on some of the most consequential cases in Southern legal history. Her dissents are often cited in law journals and are as precise as they are pointed. But Jones is no faceless bureaucrat. To her admirers, she's a bulwark against judicial activism, a jurist who believes the law should be clear, strict, and unmoved by trendy winds. "The federal judiciary has an important but ultimately limited role in society," she once declared, favoring legislative authority over judicial reinterpretation. She long resisted expansions of federal power, and in the process, her court became famous, or infamous, for rulings that narrowed civil rights protections and reinforced state authority. Her critics paint a different portrait. Those who cross her describe a judge with a biting wit and a tolerance for controversy matched only by her intolerance for what she calls political theater. Her arguments from the bench are legendary for their sharpness. She's been known to cut off lawyers mid-sentence and, during one particularly heated argument, even told a fellow judge to shut up, a lapse for which she later apologized. If legal careers are measured in influence, hers has few equals. She has repeatedly appeared on shortlists for the Supreme Court, and her judgments in landmark cases on abortion rights, voting rights, and death penalty appeals have shaped federal doctrine for decades. But with that power came controversy. In 2013, Jones was investigated following allegations that during a speech she made statements about race and crime many considered inflammatory, asserting, for instance, that certain racial groups are predisposed to crime. The official inquiry ultimately dismissed the complaints, citing insufficient evidence and context provided by supporters. But to many, the echoes of those words never quite faded. Outside the courtroom, Jones's views continue to stir debate. She's written op-eds defending her circuit's practices against criticism and accused those who question court procedures of attacks on the judiciary itself. Legal scholars, activists, and journalists alike parse her every opinion for signals about the future of voting justice and civil rights in America. For nearly 40 years, Judge Edith Jones has ruled over the Fifth Circuit with an iron pen and a sharper tongue, a mix of constitutional rigor, personal conviction, and controversy that ensures even her harshest critics cannot ignore her. In Houston's courtroom on that fateful day, she wasn't just another black robe at the bench. She was the very image of the establishment, powerful, storied, and not at all prepared for what was coming next. But beneath the surface, her legacy was already dividing the legal world in two, those who wanted to protect the system as it stood, and those determined to call out its cracks. If Judge Edith Jones was a staunch tradition, Jasmine Crockett strode into the Houston courthouse as the embodiment of disruption, a civil rights attorney turned congresswoman forged in the crucible of Texas's long-running voting fights. With her sharp suits and sharper wit, Crockett carried herself like someone who'd spent her life making herself unignorable in rooms designed to shut her out. Born in Dallas to a working-class family, Crockett understood injustice before she could spell it. Her childhood unfolded in neighborhoods marked by urban renewal but lacking real opportunity, watching aunts and neighbors navigate a system that seemed built to frustrate their every effort. From her earliest days, she was both witness and participant in the hard march for equality, a drumbeat that would lead her to the University of Houston Law Center, where she graduated determined to use the law like a lantern in Texas's shadowy corners. Crockett's rise wasn't smooth or preordained. She took on cases mainstream lawyers avoided: voting rights, police misconduct, housing discrimination, each file a footnote in the long Texas story of struggle and pushback. Time and again she listened as elderly black voters described standing in line for hours or being rejected at the polls over technicalities. Each story fueled her resolve. No policy debate was ever theoretical, not when you could recount clients by name and setbacks by bruises. When Texas's legislature unleashed its latest sweep of voting restrictions, it was no surprise to civil rights circles that Crockett didn't just tweet. She filed suit again and again, turning courtrooms into battlegrounds for the right to a free ballot. Her reputation quickly grew, a strategist who could weave together ground-level facts and constitutional doctrine and who refused to be bullied by starched collars or sneering opposition. In 2022, Crockett made the leap from the courtroom to the U.S. House of Representatives, not to play politics as usual, but to ensure that we the people actually meant every Texan, not just those able to jump through new hoops at the ballot box. She brought to Congress a spirit that was part advocate, part educator, relishing any hearing, town hall, or cable news segment where she could make constitutional rig. HTS resonate for folks who'd been told legalese wasn't their language. But her style was just as important as her substance. Crockett exuded presence, intellectual rigor mixed with the storytelling cadence of someone who never forgot where she came from. She could quote federal law without making it sound distant, and she relished dismantling bad faith arguments with facts so cleanly delivered that even opponents sometimes nodded along. Her social media presence was magnetic, offering both explanations and rallying cries. She was as comfortable going viral for deconstructing a legal technicality as she was calling out power brokers by name. When Crockett walked into Judge Jones's courtroom that morning, she wasn't just another attorney or a lone lawmaker in a navy suit. She symbolized a rising movement, one that was tired of being talked over and ready to force change from within, using the rules so often wielded against them. The old order might have been prepared for a routine argument, but Jasmine Crockett arrived ready for a showdown, a blend of lawyer, legislator, and advocate unwilling to let history repeat itself. And with every step toward the bench, she brought the hopes and fire of all those Texans still fighting to have their voices heard. If Texas dreams big, it also legislates big, and its new voting law was nothing short of sweeping. Inside that shadowy courtroom, the stakes ricocheted far beyond state lines. Every headline had warned it. The outcome here could set the blueprint for ballot access or suppression across America. On paper, Texas's rules sounded clinical. Tougher photo ID checks, tighter mail-in ballot deadlines, fewer polling sites in Black and Latino neighborhoods. But for millions, they weren't academic. They were the latest hurdles on a track already littered with obstacles. The gallery was electric with anticipation. Reporters craned for every detail. Activists, some in Protect Every Vote shirts, pressed shoulder to shoulder in the pews. In overflow rooms and on courthouse lawns, crowds watched grainy live streams, hearts pounding as the legal chess match began. This wasn't an abstract debate for the law review set. This was a real-world clash of evidence, emotions, and legacies. The testimony would be dense with numbers and expert charts, closures of polling places mapped in red zip codes, studies showing elderly and disabled voters weren't returning ballots because paperwork had become a maze. Jasmine Crockett's team brought a parade of statistics and real stories. Charts revealed that nearly 300 polling locations, disproportionately in Black and Hispanic neighborhoods, had quietly vanished since the law's passage. Mail-in ballot rejections spiked 40% overnight once new signature and ID rules were enforced. One witness recounted his elderly mother's ordeal, a lifetime voter locked out for the first time due to a mismatched driver's license address. No consultant jargon, no political theater, just stacks of data and the lived pain of democracy deferred. Opposing attorneys countered with crisp optimism. "We're protecting the integrity of elections," they insisted. "Anyone willing to follow the rules can vote." But under cross-examination, even state officials struggled to defend why rural polling sites that served mostly white voters stayed open, while urban, diverse precincts lost theirs. Each exchange sharpened a sense in the room. This wasn't about mythical fraud, but about who got to write the rules of who counts. And presiding over it all sat Judge Edith Jones, her glare fixed, knuckles tight around a fountain pen. She leaned into the questions that suited her theory, pressing every expert on why tighter regulations shouldn't be the default. But every time she called the civil rights concerns overblown, a new batch of letters, affidavits, or decades-old precedent arrived on her desk. The tension built by the minute. Every attorney sensed that whichever way she ruled would ripple outward, emboldening lawmakers in Georgia, Arizona, and beyond. Outside, those ripples were already waves. People texted updates to friends in other states. Voting rights groups posted updates online. "Watch this space," they warned. "Houston is the frontier." For many onlookers, this case was about far more than one state's laws. It was a battle over whether progress could be quietly unraveled by paperwork and neutral reforms in the name of order. As the argument spun on, no line was clear, nor any side certain of victory, but everyone in the chamber recognized the gravitational pull of this hearing. One outcome could lock a new era of restrictions in place, while another could energize the next great civil rights push. At that moment in Houston, Jasmine Crockett wasn't just arguing about ID cards and deadlines. She was standing at the floodgate, fighting for the direction of American democracy itself. And as the day wore on, everyone in the room felt it, the hinge of history swinging louder than any gavel. The courtroom tension had been simmering since Jasmine Crockett's first sentence, but when Judge Edith Jones struck, the temperature spiked in an instant. Crockett was still laying out her statistical evidence, redistricting maps, polling place closures, affidavits from elderly voters, when Jones leaned in, voice flinty and loud enough to pierce the tense hush. "Congresswoman, I've heard enough of these baseless claims. This court doesn't have time for political grandstanding." Every neck in the gallery snapped upward. The words hit like an electric jolt, as if all formality had evaporated in a flash of raw authority. A ripple of shock swept the courtroom. Reporters' pens began scratching again, and even the other judges stiffened. But Crockett wasn't done. From the folder came a second document, this one a judicial opinion from 2021. "Here, Your Honor wrote that voting rights protections are, in your words, outdated remedies for problems that no longer exist in modern America." Crockett let the phrase linger, her expression unflinching as she scanned the judge's reaction. For a heartbeat, Judge Jones's composure faltered. Her jaw clenched, and a flash of red crept up her neck. She tried to speak, perhaps to dismiss the evidence as taken out of context, but the room was already surging with murmurs. The foundation of judicial impartiality was cracking in real time. Crockett pressed forward, a third document held aloft. "And this is your dissent from 2020, arguing the Voting Rights Act should be limited because demographic changes have made its protections unnecessary." She stacked the 3 papers neatly on the podium, each a stone in the path she was paving. The courtroom was transfixed. The judge's own words, indisputable and meticulously sourced, revealed a pattern that no simple denial could erase. Across the gallery, reactions were instant and varied. Some lawyers exchanged looks that blended admiration and disbelief, while civil rights activists almost vibrated in their seats, realizing the significance of what was unfolding. For years, suspicions of bias had whispered through legal circles, but this was the moment theory transformed into the irrefutable, the private into the public. Judge Jones attempted to recover, voice unsteady. "Those quotes lack context, Congresswoman," she shot back, though her eyes didn't quite meet Crockett's. But Crockett, once more empowered by truth and evidence, was unmoved. "Context is exactly what this case demands, Your Honor. Context you've piteko provided in writing, again and again." The impact was seismic. Courtroom protocol faded as everyone realized they were witnessing the groundwork for a historic judicial accountability case. The word bias was no longer speculation. It was written, time-stamped, and read aloud for a nation to hear. But Crockett hadn't emptied her folder yet. With every page, the ground beneath Judge Jones's bench crumbled a little further, and the world outside began to stir, waiting for the next revelation that would ignite screens and news feeds across the country. The hush that had fallen after the last document was broken by something far more explosive than raised voices. A motion filed right there in open court that would detonate the proceedings and send shockwaves beyond Houston. Jasmine Crockett, face unflinching, lifted a new sheet from her steadfast folder and set it on the lectern. "Before I proceed with further arguments," she announced, her voice carrying both gravity and resolve, "this court must consider a fundamental question about fairness." The room's collective breath paused again. For a beat, even Judge Edith Jones seemed stunned. This defiance was not in the usual courtroom choreography. "This morning, before these proceedings began," Crockett declared, "I filed a formal motion seeking Your Honor's recusal from this case." The heads of attorneys, activists, and reporters whipped up. Crockett didn't just cite old allegations. She came armed with the current, the specific, and the deeply personal. "This motion is based on a documented history of statements, opinions, and conduct that would make a reasonable person question impartiality," she said, voice neither hurried nor theatrical. Across the bench, Jones's hand trembled slightly beneath her robes. The rules of federal court, stately and specific, hung over the moment. Any judge must step aside if impartiality could reasonably be questioned. But while motions to recuse are often whispered about, to lay one down, on the record, before the media, with detailed evidence in hand, this was legal warfare. Crockett pressed on. "Supporting this motion," she continued, "is a certified affidavit and detailed documentation, each fact stated with particularity, not speculation. These are not mere allegations, but evidence of bias and prejudgment that reach beyond normal legal disagreement." She drew the court's attention to a transcript of a phone call, recorded lawfully, in which the judge allegedly described the case as just Democrats trying to help unqualified people to vote. The words dropped like lead. The courtroom exploded in low gasps and hurried whispers. Crockett made clear that under federal law, not only must actual personal bias trigger recusal, but even the appearance of partiality is enough, a standard designed to uphold justice and public trust alike. "The public must believe that the judge is impartial," Crockett intoned, referencing the code and precedent, "or our trust in the system dissolves." Judge Jones shot to her feet, red-faced, denying the call ever happened. But Crockett, implacable, held her ground. "The recording has been submitted to the court's clerk, the ethics panel, and the Department of Justice for review." She reminded the bench and the nation that no judge, no matter how storied, stands above accountability. Her legal team had tabulated repeated reversals of Jones's voting rights opinions. Court clerks had corroborated inappropriate comments, and today, the pattern was laid bare not in speculation, but in black and white proofs. For the first time, Judge Jones was forced to recede, silence replacing her usual control. The panel of judges asked to assess the motion and mounting evidence. A recusal was no longer theoretical, but all but inevitable. As Crockett packed away her folder, a new sound filled the room, not just murmurs of scandal, but something deeper, a sense that the tectonic plates of judicial power had finally irreversibly shifted. Crockett hadn't just filed a motion. She'd thrown down a gauntlet that would echo in courtrooms and news feeds across America, marking the moment when the rules, long wielded for power, became the tools for accountability. The old guard had been called out by the legal code itself, and the next chapter of the fight for justice had already begun, one motion at a time. The courtroom, so recently a crucible for high-stakes confrontation, had barely begun to empty before the aftershocks pulsed out in every direction. The instant Jasmine Crockett's bold motion and on-the-record accusations echoed through the chamber, the outside world caught fire. Reporters erupted from their benches, phones to their ears and thumbs racing across screens. Within minutes, news alerts blazed across devices nationwide. Congresswoman confronts judge, bias allegations, rock federal court. Social media, already simmering, exploded into overdrive. Hashtags like #CourageousCrockett, #judicial bias, and #voting justice trended at breakneck speed. Clips of the face-off, Crockett calmly presenting evidence, the judge's stunned reaction, racked up millions of shares before the courthouse staff could even clear the gallery. Legal TikTokers broke down the confrontation frame by frame, explaining terms like recusal and judicial accountability to whole new audiences. On Instagram stories, law students and civil rights activists quoted Crockett's key line, "The Constitution doesn't turn into theater because it's inconvenient." Celebrities, lawmakers, and retired judges weighed in, some hailing the moment as a turning point for American justice. But the real consequences flared off screen. By evening, word spread that the Fifth Circuit's chief judge had ordered Judge Edith Jones removed from the voting rights case, an extraordinary move rarely seen in appellate courts, let alone with this level of public scrutiny. The panel would be reconstituted, and the matter of Jones's impartiality referred to an ethics committee. For a figure of her tenure, a legend in conservative legal circles, to be sidelined so swiftly felt epical. Legal commentators called it the breach of a once impregnable wall. The Department of Justice wasn't far behind. Citing the transcripts, phone recording, and corroborating statements from nervous court clerks, the Civil Rights Division opened a formal investigation not just into this case, but into years' worth of Judge Jones's rulings on voting rights, discrimination, and race. News outlets soon revealed that additional law clerks had come forward, describing a culture of intimidation and silence in the judge's chambers. Stories long murmured, now presented as affidavits. Outside the courthouse, a storm of activism gathered force. Local NAACP chapters and national voting rights organizations announced rallies. Hundreds filled downtown Houston holding signs that read, "No judge above the law," and "Protect every vote." The city's civil rights icons, some veterans of the 1960s, called it the biggest single leap toward judicial accountability in a generation. A TikTok video explaining Crockett's legal argument soared past 5 million views in a day as students posted threads breaking down the difference between allegations, evidence, and consequences for judges. The ripple effect radiated nationwide. In the halls of Congress, members proposed new legislation strengthening transparency and accountability for federal judges. Law schools announced emergency panels analyzing the hearing as a case study in both legal ethics and civil rights strategy. Clerks and young attorneys who had long feared retaliation whispered encouragement to each other. If it happened here, why not in our court? But the most enduring aftershock rippled inside the system itself. For decades, the black-robed authority of federal judges had seemed beyond challenge. Now, one congresswoman, armed with records and resolve, had punctured that myth in view of a nation. As Crockett stepped into the sunlight and applause outside, the message was unmissable. Power is not, and never should be, untouchable. The debate was just beginning, but for the first time, America could see, clear as headlines and hashtags, that the old patterns of silence were shattered, and a new standard for justice was on the rise. In the aftermath of the courtroom earthquake, as Houston's courthouse emptied and news alerts echoed across the country, the landscape of American justice looked fundamentally different. It wasn't just the forced retirement of an iconic judge or the viral victory of Congresswoman Jasmine Crockett that signaled change. It was the deeper, collective realization that the old rules of untouchable judicial authority had been rewritten, one folder and one fearless confrontation at a time. For years, the architecture of the federal bench had seemed impervious. Judges, cloaked in tradition and lifetime tenure, operated under the assumption that challenges to their impartiality would fade as whispers or be buried in legal footnotes. But Crockett's actions proved that even the most established guardians of the status quo could be held to account, provided the evidence was irrefutable and the resolve unflinching. The precedent had been set in broad daylight. If bias exists, let's name it, document it, and challenge it before the world, not only behind closed doors. Civil rights lawyers took note, emboldened to push for greater scrutiny in their own courtrooms. Law clerks who once endured retaliation in silence now saw a model for whistleblowing and solidarity. Even within the judiciary, conversations shifted. In conference rooms and chambers, the Everest of judicial immunity had lost some of its snowcap. For the first time, ordinary Americans joined the conversation. Hashtags like #JudicialReckoning and #NoJudgeAbove. The law moved from trending topics to rallying points. Downtowns from Houston to Atlanta filled with protesters demanding transparency, ethical oversight, and a bench that reflected not just legal expertise, but the diverse realities of the nation. Law schools rewrote syllabi to feature Crockett versus Jones as a benchmark for 21st century legal activism. And crucially, lawmakers responded to the seismic shift. Congressional hearings on judicial ethics gained momentum with bipartisan support for reform bills mandating public disclosure of conflicts, expanding avenues for recusal, and protecting whistleblowers in the federal judiciary. The public's faith in the rule of law, one senator declared, depends not only on consistent rules, but on the willingness to confront when those rules are bent. In living rooms, social feeds, and college classrooms, the name Jasmine Crockett became shorthand not for celebrity, but for a new standard, standing resolute when power demands silence. The viral footage of her defense, calm, direct, and precise, became a masterclass in using facts and law to turn the latticework of tradition inside out. Yet this new era is not defined by a single victory or the fall of one judge. The tremors set off in that Houston chamber continue to reverberate, a reminder that the shield of justice gains strength not from secrecy, but from accountability. American democracy, for all its imperfections, depends on courts unafraid to see their own shadows and a citizenry unafraid to shine a light. As Crockett left the courthouse surrounded by supporters, the message was unmistakable. The rules are finally changing, and the power once reserved for the few is now a charge given to all who demand fairness. In a country built on the idea that no one is above the law, a new chapter was being written, one with room for every voice, every challenge, and every hope that justice will not only be done but seen to be done. The gavel may rest for now, but the echo promises more. Judicial accountability is no longer a distant goal, it's the new ground beneath our feet.